going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Thursday. Yeah, it's Thursday. Happy Thursday. One more day left, and then the weekend. All right, you guys want to watch some court? I want to watch some court. Let's watch some court. I've got a lot of Judge Washington tonight. I kind of camped out in her courtroom today for one very specific reason. Miss Lindsay Dineski was due up today and waited there for about an hour, and I don't know, I think she came up at about 10:30ish. Her case was adjourned. It lasted about 30 seconds, so that was fun. Spent all day in the courtroom waiting for her, and then just a quick adjournment. But you know what that means? We get another Lindsay Dineski case in about a month. I'm not sharing the case. Nothing happened. Honestly, she came up. They asked for an adjournment. They adjourned it. That was it. Nothing else happened. But I did see a couple interesting cases while I was waiting, and a couple afterwards. So we're gonna watch some of those. And then I got a bunch of random stuff to round out the night. It's gonna be fun. We still have a good show tonight. And yeah, you know what? That's all I'm gonna say. So before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go. Oh, there was one more thing I wanted to say. I used a different editing software. My editing software, for whatever reason, wouldn't open. There was a lot of tech issues today. I used Canva for my thumbnails. That was down for a bunch of today. StreamYard wouldn't let me download videos that I was recording, so that's why I didn't have any videos posted today. I feel like everything I was using was not working. I did find another editing software that did allow me to edit the video. So if there's any editing mistakes, I'm sorry. It's the first time I've used this software. But you know what? Let's go.
Yes. Thank you. Can you let everybody know? Thank you. State of Michigan versus Derek Radecki, case number 24 FB 1410.
Tiffany Woods for the people.
Public Defender Davi Leba from Mr. Radecki. Mr. Radecki, can you see your name, sir?
Derek Radecki.
Thank you. We're here for a review today.
Yes, sir. I've reviewed the report with Mr. Radecki, and you would accept the recommendation for some additional time to get his requirements done.
Anything from the people?
Nothing from the people, Judge.
Well, I have some concerns. Mr. Radecki was apparently very rude and disrespectful to staff.
Yes, sir, and I did talk to Mr. Radecki about that, and he does regret that behavior, and he's going to apologize. Mr. Radecki?
Yes.
Would you like to apologize for the conversation you had with probation?
I don't believe I said anything incorrectly to them, so.
I think yesterday we talked about you apologizing.
You asked me if I wanted to.
All right, that's okay. He doesn't have to. So I don't have to follow this recommendation. You don't want to get you don't want to get it done. We're going to do a formal violation and just handle this formally. All right, I'm going to bring him back here. A formal violation will be filed. I'll see him on July 3rd.
I'm not going to be in town.
Well, then I'll issue a bench warrant and then we'll get you in town when you come back. Okay?
Okay, well, have a nice day.
apologize for that, Your Honor.
It's okay. It's not your fault.
Thank you.
We might as well do the bench warrant right now.
I would ask for an opportunity to persuade Mr. Radecki to appear.
Hmm. All right, I'll give you that July 3rd at 10 o'clock a.m.
Thank you, Your Honor.
Yeah, that was a quick one. That was a quick one to get the night started. Do you want to apologize for how rude you treated the staff? No? Oh, we talked about that, didn't we? Yeah, I don't want to apologize. All right, well, bye. Yeah, it's not going to end well. I do like how Judge Washington was just, I'm just already going to file the warrant for failure to appear. I don't know if she can do that. She'll file the warrant for a failure to appear for something that's going to happen in 3 weeks. I don't know. She's a judge. She might be able to. Who knows? But I thought it was hilarious. I doubt we're going to see him on the 3rd. I have it written down. We'll see. But I cannot wait for his next appearance. It is not going to be that quick. I promise you that. Another Squid, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you. That was very generous of you. I appreciate it. You're awesome. And I said awesome again. Yep. Didn't learn anything from last night. Let's keep the show going.
We'll call the matter of the state of Michigan versus Silas Sherrod, case number 24S00324.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Silas Sherrod. Silas, can you state your name for the judge?
Silas Sherrod.
Thank you. All right, we're here because I believe the bail bondsman wanted me to set a hearing indicating that the court couldn't reinstate a bond.
Yes, Your Honor. Raymond Woodburn with A1 Bail Bonds.
Yes.
Yes, Your Honor. Oh, I apologize.
What is your basis for that argument?
Yes, Your Honor. We had received notice on 4/21 that he had failed to appear to court. When we received those notices, it's our understanding that the court either wants him back to court or would like the money for the full amount of his bond. We did go out. We had him in custody on the 29th. He was put in Washtenaw County Jail, and we sent all the appropriate paperwork in for bond discharge and proof of incarceration on the 30th. Since we had to go out and arrest him for failing to appear, we are requesting respectfully under the Michigan Compiled Laws 765.26 subsection 2 that we would respectfully be released from the bond.
Judging by the look of Mr. Mansour's face and Mr. Sherrod's face, they did not see this coming. They were not prepared for this. Like, uh-oh. Yeah, you did this to yourself. You didn't show up. Madam, thank you so much for becoming a member. I appreciate it. Welcome to the family. Thank you.
What's the statute you're citing?
It is MCL 765.26 and then subsection 2.
Yeah, I figured, man. I figured. That happens. YouTube likes to glitch, especially with all the internet stuff today. Doesn't surprise me. But thank you. I still appreciate it.
All right, Mr. Mansour, I'm pretty sure you need to look that up as well.
Yeah, Your Honor, that's correct. I'm looking it up right now.
Ooh, dead time that I missed. How are you all doing today? I have no idea what I'm going to talk about. I've got a bunch of soft sits to play tomorrow, since StreamYard didn't let me make videos today. Got three soft sits from today. It's going to be a good day tomorrow. Hey, a girl named Joe. That's good. It's hot in Ohio today. Actually, it's not too bad. It's not too bad. It's warm in Ohio today. Let's just say that. Hey, what up, Left Turn? OH. Yeah, I know, right? I don't know how long this gap is. I guess I should start fast forwarding it. I thought it was only going to be about 30 seconds. They're looking up the statute that he just cited, or the court rule. Oh, so many IOs. Lots of IOs. Hey, Legal Fiction! Thank you so much for the 10 gifted memberships. That is very generous of you. Welcome to the 10 new members. Thank you, Legal Fiction. You are awesome. I am not going to give up my word. I'm not. Where I'm right now.
Did you request that the jail release you?
I am an hour north of Cincinnati right now. I am outside of Dayton. I grew up in Cincinnati, though. I wasn't born there. I was born in Illinois, a small city, in not Chicago. So pretty much, if you say Illinois, people assume Chicago. Wasn't Chicago. It was another part of the state. Moved to Cincinnati. I spent 38 years in Cincinnati. But yeah, moved up here for a job, and now I'm a YouTuber. Yeah.
I'm sorry, Your Honor.
It says that the jail can do that.
All of my experiences, I've have to send something into the presiding judge to be released from the case. That's why we sent it into the court the next morning.
Yeah, but I haven't revoked his bond, so I don't think you get discharged.
Once they fail to appear on, the court actually raised his bond to $50,000 on 4/17, Your Honor, when he failed to appear to court, and then sent the notice out.
And then we reinstated it.
You are so close to me. I don't want to say exactly where I am on YouTube, but you are really close to me. I will say that. Yeah, really close. But while I'm paused, Legal Fiction, 17 months. That is awesome, my friend. Thank you so much. We're killing it tonight. Your name's just green.
For the same amount.
Correct. But we were requesting to be released from the bond. We have the right to revoke it at any time, Your Honor.
Where does it say that in the court order that you signed?
It's in our contract with the clients.
Well, that's between you and the client. That's not what our order says on the back. Mr. Mansour?
Yes, Your Honor. So when I was before Magistrate Braley, that was on the 30th. Magistrate Braley ordered that she reinstated his cash or surety bond so he could get the $25,000 bond back. She did issue a $50,000 personal bond, but then, as you stated just now, the bond has been reinstated, and he just took a plea not too long ago, so technically he's still on bond right now with the same conditions.
He's claiming though he wants to revoke his bond.
Yeah, I'm not sure why. Maybe according to his contract or the contract between the bail bondsman and the client. But
I am very sorry to interrupt. Once he failed to appear to the court, we're either responsible for bringing him back into court or being responsible for that $25,000. We did not want to pay that $25,000. That's why we went out, arrested him, put him back into Washtenaw County Jail to be released from the bond. So we were no longer held responsible for that $25,000.
Mm-hmm. But the court didn't discharge your bond at any point in time.
Correct. And I was trying to find out why that was. He did not appear. We followed what the court wanted us to do.
And if
We've seen this happen a lot in Kansas. Judge Webster gets bail bondsmen all the time, asking for them. They want to be released off a bond, and it's always a hearing like this. I find this very interesting. I really do. But you could Judge Washington, Attorney Mansour. They don't Mansour. I don't know how to. I'm mispronouncing it, but you can tell they don't get this a lot. I don't know if I've ever seen this in Michigan, where a bondsman shows up to court. You know, he filed his own motion to revoke bond.
If I may, I believe Silas or Mr. Sherrod was taken into custody when he was at community corrections, appearing for a drug test. So I believe he turned himself in.
No, sir.
That's what
No,
I was.
sir. We went out in a.
No. Well, no, the bondsman keeps the money. Yes. So, you know, they're saying he doesn't want to pay $25,000. So I'm guessing it was 25,000, 10%. The defendant paid him 2,500. Now I'm just guessing, but that 2,500, that's the bondsman's. They fulfilled their obligation. They're not the ones who broke the contract. The bondsman would keep that.
Arrested him on the 29th, 4/29. I also sent over proof of incarceration that we took him to Washtenaw County Jail. I was there myself, so I know that happened.
Well, I'm going to take your requests under advisement. I'm not going to discharge the bond today.
Okay, Your Honor. May I ask a question?
Mm.
If we revoke the bond and go and arrest him again and place him back in custody of Washtenaw County Jail, would we be able to get off the bond then?
I guess I don't know the answer to that question right at this moment. Sir, I don't. And I don't know what your contract says about whether you can do that. That's between you and him. So I don't know. Do you want to speak to the bail bondsman, Mr. Mansour? Because it sounds like.
Oh, yep. That was Michigan. That was Judge Coretti. So yeah, that was only about a month ago. That was a lot higher of a bond. And the guy was in jail for, oh man, that was a weird story. I remember that sparked a fun discussion in the comment section. Most people were polite about it. That was a good one though. But you're right, there was one in Michigan that just happened.
Okay. Arrest your client.
Yeah, Your Honor, that'd be greatly appreciated.
I
Thank you.
don't know. It's an interesting question, whether people can just get arrested because the bail bondsman no longer wants to comply with the bond.
Well, Your Honor, it's not that we don't want to comply with it. He failed to appear.
Stop. He said stop.
Yeah, I thought he was too.
Testing. I apologize, Your Honor. We're back up and running on the record.
All right, you may keep talking.
Yes, Your Honor. It's not that we did not want to comply with the bond. It's that he did not comply with the bond and failing to appear to court. And this isn't the first time that has happened with your court. And Mr. Sherrod. So when we did have to go and find him, we did not want to pay that $25,000, Your Honor, and we still do not want to pay that $25,000. That's why we were hired to go pick him up and put him back in custody. And once he is back in jail for a failure to appear, because he did not follow the bond conditions of the court, which is appear to his court dates, that's why I stated the MCL, because we should be relieved from surety at that point once we put him back in custody.
I heard you. I read that. And I think one of the issues that we have, Mr. Mansour, is if he was continuing to follow his bond, then I think that the bail bondsman wouldn't have a valid argument. But the reality is he has a pending bond violation right now. So that presents as a bigger problem.
It does, Your Honor, but as the court's aware, that is scheduled for a hearing. We have.
I know, but bail bondsman is saying that he doesn't want to be responsible for this individual. And if he didn't have a pending bail bond, he didn't have a pending violation and he was just reinstated, I would feel like telling the bail bondsman go away, but he's got a pending bond violation right now. So he makes a valid point. He doesn't want to pay that.
Well, Your Honor, that's if it's proven that, so the bond hearing.
I don't know their contract is what I'm trying to tell you. I don't know their contract, and he's saying he has the right to do that. So I'm gonna let the two of you go into a room and talk, and then when you come out, I'll talk to you both again, and we'll see where we land. How about that?
Thank you, Your Honor.
You're welcome.
Oh, that's also unusual. I mean, I don't know if it's unusual. When I've seen, the bondsman show up in Judge Webster's courtroom, I've never seen the defense attorney want to talk to the bondsman, but whatever, we're getting through it. Okay, let's knock these out. Kat in Virginia, thank you so much for the super chat. I drive from Virginia to Chicago to see my family sometimes. I've stayed in Dayton once. I've been in the kind of the Dayton area for 3 years now. I've never been to downtown Dayton. Haven't been. I just kind of stay in my little area. Carolina, the agility partner, thank you so much for the 2 months. I appreciate it. Artie Foss for 5 months. Thank you so much. And Rich. See, I'm not going to miss you tonight, Rich. Late fee and Wang Chung royalty fee contribution. Thank you so much, Rich. I appreciate it. Okay, let's keep going.
Yes, Your Honor. This is Matthew Mansour, Assistant Public Defender on behalf of Mr. Sherrod.
Tiffany Woods for the people.
Thank you.
Good morning, Your Honor. Ray Woodburn with A1 Bail Bonds.
Thank you. Good morning again.
Good morning. Or afternoon.
It's afternoon at this point. All right. Everybody had a chance to talk. Did we have any success or no?
Yeah, Your Honor, I believe so. Thank you for that opportunity. So, Your Honor, just to recap, I spoke with Mr. Woodburn about this. On February 6th, Mr. Sherrod was given a $25,000 cash or surety bond, a warrant for $25,000 cash or surety. On March 15th, A1 bail bondsman was appointed or was hired by Mr. Sherrod, and Mr. Sherrod paid A1 bail bondsman $2,500, which was 10% of the $25,000 bond. So he posted bond. On April 30th, we were in front of Magistrate Braley, and Magistrate Braley reinstated bond, but changed it to $50,000 PR bond. So that's what his bond is now. And is all that accurate with your files as well?
Mm-hmm.
So February 6th was the 25K.
On April 30th, she reinstated the 25,000 cash or surety bond.
Correct, but it was a PR bond.
No, it was not.
Your Honor, I was in front of Magistrate Braley on that. It doesn't show on JIS, but Mr. Sherrod left
in our file. It's a $25,000 cash bond, which was already posted. She reinstated the already posted bond.
Right, Your Honor, but I specifically remember her saying 50,000 PR bond, which okay, it is what it is. What his bond right now, according to the court, is what?
$25,000 cash or the surety that was posted.
Every time I say your name, I always say Carolina first. And then I always catch myself. I did not catch myself this time. I'm sorry. Kalina. I see your name and I say Carolina. I know. Every time. I apologize.
Stated the bond he originally had, Mr. Mansour.
Well, that's where I guess I'm a little bit confused. Because
but that's what the bond is.
Okay. So, all right, Your Honor. So I spoke with Mr. Woodburn, and he let me know that what he's intending to do is just be relieved as a surety from Mr. Sherrod's bond. I asked him what the ramifications of that would be. So the $2,500 that Mr. Sherrod paid, but obviously it's forfeited to A1 bail bondsman, and A1 bail bondsman is no longer a surety to this case. So we're okay with that. But
then he goes to jail.
Yeah, see, that's the problem, Your Honor.
You're correct. That is the problem.
I'm under the impression that he could be. I'm under the impression that he's on a PR bond for $50,000 cash or surety. But if you're saying it's not, it's not. Then we're not at a resolution, Your Honor, because and if the court would, we would be okay with releasing A1 bail bondsman if the court would allow Mr. Sherrod to be on a PR bond.
How would I do when he's right now standing in front of me with a pending violation? I'm definitely not doing that.
Well, Your Honor, that's what I was hoping for. I was hoping you would, due to the fact that he has paid a bail bondsman.
But you know, please, Judge, please. I love that. That's a really good legal argument. I was hoping you would. I was hoping, please.
He showed up.
Bondsman. This court has set a bond. That bond is $25,000 cash or surety. He either posts that or he goes to jail. That we're not going to continue to discuss.
Okay, Your Honor, but he's pled on this matter.
I'm not going to continue to discuss that. I can handle this one of two ways. You guys can work it out. He can not work it out and go get his bond back and then arrest the defendant, or I can just issue a warrant today. Those are the options. Your client continues to test positive for THC and amphetamines, and you want a hearing on that. We're having a hearing. He needs to have his bond. It's just that clear.
Your Honor, if I may.
You may.
Okay, Your Honor, when we posted the bond, we did it in good faith that he would be following all of your conditions. He did not. You let us know. We brought him back into custody. He was in jail. The ends of justice were thwarted as far as we are concerned. That is why we requested to be relieved for the bond. We're not understanding how we got placed back on the bond when he didn't do what he was supposed to do. We took care of the matter. I'm trying to...
Mr. What is your name again?
Mr. Woodburn, Raymond Woodburn.
Mr. Woodburn. He was seen on April 30th before the discharge came to me. I never signed a discharge, and I'm the only person that can sign a discharge. So when the magistrate saw him on April 30th, she has a note right in here saying that the bond was reinstated. She reinstated the bond.
That's why I'm trying to figure out, Your Honor, of why that would happen if we had to go out and arrest him for him not doing something that the court wanted him to do.
Because the magistrate chose to do that before we got a request for a discharge. That's what happened.
Okay, the request was sent over the very next morning, the morning of the 30th, to the...
Don't spoil it, HCC. She's next. She is next. I know. I saw, let's see, OSG, I think Mike also covered her. She's next. Anyone who's seen Brianna, do not spoil it. She takes the cake on drama in Judge Washington's courtroom today.
Court.
You know,
And a phone call.
argue with me all you want. It's not going to change anything. I've heard what you said, and I've heard what you said. So if you want to go rearrest him and put him back in custody, then that's what you can do if that's what you say your contract says. And at that point in time, he will not have his bond reinstated because you're revoking it. But at this point, he's out. The bond was reinstated before any discharge was signed. The court speaks with his orders, and there was no order signed saying that it was discharged. So therefore it was reinstated before it was discharged. That part is done. You want to go and pick him back up? That's between y'all, and I let y'all talk about that. If he gets picked back up, the bond is still going to be the same, but they're requesting to have their bond revoked, and I will sign that.
Yes, Your
And
Honor.
I still have nothing from you, Mr. Mansour, as to why your client continues to test positive for amphetamines.
Your Honor, we're going to challenge that.
I heard you. You can do that.
We're going to challenge that. And, you know, this is a kind of unfortunate, and I feel as if this is unnecessary as well at this point.
The bail bondsman wants his money back, so that's...
It's not unnecessary. They had to pick him up because he failed to appear. He went to jail and his bond was reinstated. The bonding company thought they were off the bond because they had to pick him up and take him to jail, and then it was reinstated. They didn't know, so they filed a motion to take. They don't want him anymore. They don't want to be the responsible party for him. It's not unfortunate. It's how it works. They just missed the step where they got put back on the bond without their knowledge. That's it.
It's between him and whoever he decided to do his bail bondsman with.
Right. I mean, I don't know. Mr.
That would be
Sherrod.
the court, Your Honor.
I'm sorry, what?
That would be the court, Your Honor. We don't want to owe the court the $25,000, Your Honor. That's why I came on today.
What I said was, he chose you as his bail bondsman. That's up to you guys. Those are the questions you guys have. That's your contract.
Yes, Your Honor.
I'm glad you're here now, Mary. Hello. What's up, Mark? We got Mark and Shane in the house. Phil, we're filling the chat up tonight. How are you doing, Mark? Oh, Mark, we've got someone that you might be able to fix here in a second. Her name is Brianna. Brianna likes Mark. That's it. Brianna likes Mark. Laura, you know what? I did see that. I don't usually cover body cams on my channel. When I do, nobody watches them, and I don't know why. I found some really good ones. I found the Eric Martin one, and it just it didn't. The views were just really low, so I've kind of stopped doing body cams, not unless they're part of the court case. It was a very good one though, and who was it? Kfar posted his link of him reacting to it. Not that was perfect. Mark probably covered it too. Shane actually probably covered it as well. Yeah, but it was a very good one. So thank you so much for sending it to me.
So at this point in time, the order from this court, well, the decision that I've made is I'm not going to revoke the bond today. If you pick him up and request that your bond be discharged, we will sign that discharge at that time. Otherwise, this case is on the docket for July 1st, 2025 at 11 a.m. for a hearing.
Yes, Your Honor.
All right. Thank you.
All right, and that's it. Let's see, Shane. She's talking about the body cam where the woman was using a wet wipe as her cell phone. She was using her garage door opener as a breathalyzer. She was saying that she was on her way to the cemetery because her grandmother just passed. She was beyond drunk. She was beyond drunk. Okay. Now we're moving on to Brianna Likes. All right, Mark, this one's for you.
I need to write that. Do you want me to write the new date in? Thank you. The court will call the case of the state of Michigan versus Brianna Likes, 25S00120.
Brianna Likes.
Assistant Public Defender Davey before Ms. Likes.
Ms. Woods, can you place your appearance on the record?
Tiffany Woods for the people.
All right, thank you. So we are originally here for a pretrial in this particular case. The court passed the matter and Ms. Lake's camera was off and the court was unable to see her. In the interim time period, Ms. Likes apparently turned her light on and then put in the chat "This is bullshit. I have a different court to be at as well." So first she's cursing in the chat. And then secondly, I have an image of her giving the middle finger to the court. And as I indicated before I recalled this case, Ms. Likes is going to be found in contempt of court regarding both of those decisions that she made this morning, and she's going to do jail time. You have a right to have a hearing on the contempt proceeding. You can request that if you so choose. Mr. Lebo, what would your client like to do?
Ms. Likes would admit to both.
Ms. Likes, is it true, ma'am, that you wrote in the chat, "This is bullshit"?
It was not supposed to go to the chat. It was supposed to have went to a family member that I was responding back to, and somehow it ended up going to the chat, and it was not supposed to have. The part where I did say that I do have another court as well, that was supposed to have gone into the chat for you guys, but the other part was not supposed to have.
Now, my question was, did you put that in the chat?
No, I did not.
All right. Then we're going to have a hearing.
Ms. Likes, are you sure you want to deny putting that in the chat?
I mean, like, what else am I supposed to do? Like, it was not supposed to have went to your guys' chat. Like, so screw it. Like, it went to your guys' chat. I understand that. Like, so what are you suggesting I do?
Ms. Likes, would you like to have another breakout room with me?
Sure.
Possible.
Look at Judge Washington. Oh, it's priceless.
Are we gonna do a breakout room?
You can give them the breakout room.
I'm sorry, I was waiting for you.
We call the matter.
All right. I'm pretty sure everyone that's ever sent a text message or used any kind of text technology to send messages have done that at one point or another. You're typing, you think you're typing to one person, you hit enter, and then you realize, oh, wrong person. That is possible. She could have just said that. No, she had to say, I didn't do it. She said she didn't do it. Yeah, after she said she did do it.
Matter of the State of Michigan versus Brianna Likes, case number 25F00120.
Tiffany Woods for the people.
Assistant Public Defender Davey Liu on behalf of Ms. Likes. Ms. Likes, please state your name, ma'am.
Brianna Likes.
Thank you. What would your client like to do?
Ms. Likes, at this time, would you like to admit to the contempts of court that were discussed?
Yeah.
Thank you.
Ms. Likes, please come to the camera.
Yeah.
Please.
Can you guys hear me?
Yes. Ms. Likes, is it true?
We can hear you, but if you don't mind turning your camera off, we don't really want to see you. Ooh, was that mean? That was mean. I think that was an inside thought that came out. I probably should have kept that to myself.
That you put, "This is bullshit" in the chat.
Not meaning to, yes.
Is it also true that you put up a middle finger at the camera, ma'am?
Sure.
That's a yes or no. That's not a sure.
Yes.
Defendant is to complete 10 days in the Washtenaw County Jail. When does she want to turn?
And I do apologize for doing what I did.
Yeah. That's not. That was the worst apology ever. That was not sincere. That's her being, oh, now I got to do this. I sentenced you to 10 days in jail for contempt. Oh, well, then I guess I apologize. Yeah, good luck.
And it won't ever happen again.
Oh, Judge Washington believes her.
Is there anything from the people on this?
Judge, I just know that she's here for a case, a child abuse case, Judge. So I know she has a young child, I believe a 4-year-old. I just would like for the defendant. I would just like for the defendant to take a look at her behavior.
Eating. She's not going to look at her behavior. Now she's eating in court.
I have a deficiency where my sugar drops really, really low, so I have to eat something because my sugar did drop really low. And I did just take it to make sure that my sugar was low, and I do apologize for that, but I have to eat something to bring my sugar back up.
I just think she's setting a poor example for her children, and she's setting a poor example for the judge and the people as to how we're going to resolve this case. And that it doesn't look like she appears to be taking any of this seriously. In court, we all wait around for the hearings, whether the hearing is scheduled at 9 or...
Yeah, you guys are saying that you don't believe her. How fast she came with that answer. I mean, if she's lying, she's been lying about that for a while. She said that so quickly. I don't know. When people make medical claims, I'm never going to second guess them because I don't know. I don't know enough to be able to say you're wrong. And I'm never going to say you're wrong to someone that says they have a medical issue. So I'm going to believe her. I'm going to believe her on the eating.
10 or 11. It's frustrating, but it's something that as an adult, we sit quietly, we pay attention, because that's the right thing to do when you're in court. And as a mother who's setting an example for young children, I would have liked to have not have this happen, because I think that the defendant right now is setting a very poor example for everyone, including her children, Judge.
Anything from you, Mr. Lebo?
I would just ask that the court consider an alternative sanction such as community service, this perhaps an anger management program.
Defendant is to complete 10 days in the Washtenaw County Jail. I'm going to hold that in abeyance. Defendant can do an impulse control class. To purge her contempt and not do jail time.
Thank you, Your Honor. I'm sure Ms. Likes very much appreciates that.
Mm-hmm. Thank you. And I do apologize for me eating, but I have to bring my sugar up.
What do we do regarding the pretrial?
Your Honor, we're going to set that matter for a bench trial, please.
For what trial?
A bench trial, Your Honor.
Are you sure that's what you want to do?
Could we approach for a moment?
Sure.
Hello, Judge Washington. Are you sure you want to have a bench trial after we just went through that?
Brianna likes matter. We had a chance to talk about this particular matter. I explained to the prosecutor the court's position with respect to how I view the law regarding child abuse fourth degree. The prosecutor has been fully informed on that. I am familiar with some basic outline of the allegations in this case. The court would obviously be fair with respect to this particular charge. However, I think that the prosecutor needs to speak with supervisor about the court's stance regarding the law as it comes to the child abuse fourth, and Ms. Likes needs to get her.
Yeah, she's got an oxygen deficiency, so she has to smoke cigarettes every time after she eats to make sure her oxygen stays up. Yeah, I just made that up. I did. That was me. That was on me. I don't know her medical issues. I don't know why I said that. Hopefully it was funny.
Course done so she can purge her contempt.
Come find me.
We'll put this all over to July 10th. And at that time, we'll see whether or not we need to have a waiver and whether the prosecutor would waive, given the court's position regarding child abuse fourth degree. All of those are things that, because the prosecutor would have to waive to a non-jury trial as well. So those are all the things that need to be flushed out before we are in a position to move forward. And so we'll put this to July 10th at 9:00 a.m.
Thank you, Your Honor.
Ma'am, you need to contact the probation department so they can advise you of how you can get that class taken so you can purge your contempt.
Ms. Johnson already provided that information.
I did just receive that in an email from Ms. Johnson. I'm going to forward that to Ms. Likes right now.
Thank you.
Thank you.
You're welcome. We'll see you back then. Bond is continued.
Okay, and that'll be July 10th at what time?
At 9 a.m. It's on Zoom again, ma'am. Okay.
Okay, thank you.
Oh man, I bet Judge Washington cannot wait until her courtroom is finished and she can go back to doing things in person. I can wait because that might mean we're not going to see her on YouTube anymore. Hopefully that doesn't happen. But that's why she has to do everything by Zoom right now. She doesn't have a courtroom or a courthouse that's accessible. I guess that's a better way to say it. All right. We are leaving Judge Washington's courtroom. I don't remember what's next. I have one video that I'm going to have a headphone warning on because the audio is weird, and I really hope it's not the next one.
There you go.
Oh, no, not this one. This one's just normal. I think it's the next clip. The audio goes really loud and really quiet. You'll see what happens.
This is 25 IRO 02657. You were ticketed on the 25th of April, a quarter after noon. You're Durham and 13 Mile for impeding traffic. The officer gave you a ticket for impeding, which does not carry points, instead of giving you a prohibited turning ticket, which would carry a couple 3 points. Are you here to accept the break the officer gave you on the street or to reject it?
Yeah, no, the signs literally just got posted, and I wasn't completely aware of where I could go and or what I should do. So personally,
yeah, I'm asking you, are you admitting or denying responsibility for the infraction?
I mean, it was a newly posted, so I mean,
are you admitting or denying responsibility, sir?
I'm not like denying it that I made the left-hand turn. I just wasn't aware on where I was supposed to go. So
if you're not denying it, you are admitting it, correct?
Okay.
I'm not trying to put words in your mouth. I'm trying to figure out.
I was trying to figure out where I can make that left-hand turn. So I made the
trying to figure out if you're admitting or denying responsibility.
I mean, I guess I'm denying because I wasn't aware of where I could go.
Please raise your right hand, please. Raise your right hand, please.
Oh my goodness. So if I deny it, then that is.
You're not going to take an oath. I'm going to find you responsible by default. You are the one that scheduled a hearing.
Okay.
Now we're going to have a hearing, and the hearing is done under oath. You either swear or affirm. And if you're not willing to do that, you're not going to get a hearing, and you are going to pay the ticket. So which way do you want it?
Okay, I'm omitting to fault for making a left-hand turn, even though I didn't know where to go. And then when I made that left-hand turn, she called another officer, had me hop out of the car, and then she tried to search my vehicle because I had a legal piece of glass in my back seat.
She gave you a break by giving you a fraction
I
of necessary points.
I understand she gave me a break, so that's why I'm omitting.
Fine is $175. It can be paid online or by mail, or you could stop by the courthouse and pay it at the counter, sir.
Okay.
Thank you. We're done.
Yeah, that was a quick one. Yeah. Yeah, he wanted to plead guilty with an explanation. And I want to know what this legal piece of glass he had in his back. You know, if the officer wanted to search his car because he had a legal piece of glass in his back, he had a bong. That's what he had in his backseat. That's the only thing that makes sense. They saw potential drug paraphernalia and wanted to search your car. It might be legal, it might be clean. Still drug paraphernalia, but he's calling it glass. It's cute. All right. I do think this next one is the one that it's so hold on, let me just make sure before I give this explanation. Yeah. So the jail is extremely loud, but the courthouse is soft. There was very little I could do about this. If you guys have headphones on, you might want to turn the volume. You're going to be adjusting the volume up and down. I'm going to be trying to do it on my side. It's annoying, but this case is kind of funny, so I wanted to share it.
Good afternoon, Mr. Simpson. You've been charged with criminal trespass under section 2911.21A3 of the revised code, and that is a misdemeanor of the 4th degree. It carries with it a penalty of up to 30 days in the Licking County Jail and a fine of up to $250. Do you understand that charge against you, sir, and the potential penalties?
Yes.
You can enter one of 3 pleas here today. You can get a plea of not guilty, guilty, or no contest. Do you understand what those 3 pleas represent?
Yes.
And do you know what plea you'd like to enter here this afternoon?
Yes, I would like to enter a not guilty plea.
All right, court will accept your plea of not guilty. You're listed as on here as homeless, Mr. Simpson. We may be able to get you into the home court, to assist you with that. I'll have you referred for that. Here's what I'm going to do. I'm going to make this a recognizance bond, but I'm going to have some terms.
Well, yeah, but so he's sitting. Judge Stansbury's on vacation, and he's been sitting for him since last week. It's been about 2 weeks that Judge Landefeld has been there. So he just brought his own nameplate. So they're different names.
Terms and conditions. I don't want you to consume any alcohol or illegal drugs while this matter is pending. You'll be subject to random drug and alcohol testing with the probation department, and you'll submit to all bodily substance tests requested by law enforcement or probation. While this matter is pending, I want you to stay away from Family Dollar, okay?
Yeah, I understand you, but I have to also let you know that there was a misunderstanding because of me being said to be someone that criminally had trespassed. There's no signs there, and I was there doing like tutorials, and I just need to make sure that that's mentioned because of the activity that's around, and just to make sure things are understood. That those things
I don't mean to cut you off here, but
totally illegal.
I don't want you to say anything. You've entered a not guilty plea. I don't want you to say anything that is going to jeopardize that. Remember, these proceedings are being recorded. And
oh yes, definitely, I know.
Let's not say anything at this point. Let's get you an attorney. Fill out that application for court-appointed attorney.
Well, I'm not going to use an attorney at all. I represent myself, and like I said, I plead not guilty, but I want these charges and everything and stipulations to be thrown out because I'm definitely not someone who trespassed, and this matter is like a totally illegal matter for me to be here, and I think it's best for me to let that know or be known.
Mr. Simpson, you can represent yourself if you wish. Abraham Lincoln had something to say about that. A man who represents himself as a fool for a client. So
Shout out to
I
Abe
want you to be
Lincoln.
aware of that. I want you to come here and report to the probation department as soon as you're released, okay? Good luck to you, sir.
All right, and once again, I just wanted to let you know that when the time is most convenient, after these matters are reviewed appropriately, I want it to be known that these charges need to be dismissed because of the probation and things that are to be said, of which is simple for me to be a part of. It's unnecessary when you think legitimately of the matter and you think about the propriety of the situation, of which I need to be a part of having all of these charges dismissed immediately as soon as possible. And this is something that's very important. Thank you very much, and you all take care.
Oh, hold on. That's not it.
Deputy, I believe that's everybody, Lisa.
Yes, sir.
Okay, thanks so much for your cooperation, and have a good day.
Thanks, you too.
Okay. Now, is that good for you? Okay, it was good for me too. But now we got to get down to business, and I'm sorry about that. This may not be quite as much fun for everybody, but our first matter here.
Oh, I love that. I had to keep that part in. That part was good. You gotta love visiting judges. So this judge has been giving everyone like $25 fines for the last 2 weeks. Like, you just come in, it doesn't matter what it is. He's like, okay, you're pleading guilty, $25. How's the $25 fine sound? Oh man, it might be his last time as a visiting judge, but I love him. He's definitely a grandpa judge for sure. All right, I don't know where we're going next. This one's thank you to Lucy. Lucy let me know that this happened. This is not a court that I watch a lot of anymore, and I don't really know why. I just kind of took it out of my rotation. This one's just kind of weird, kind of funny, and interesting all at the same time. Let's go. And the volume's back to normal, guys. Don't worry.
Going with Mr. Richardson this morning.
Good morning, sir.
Good morning, Mr. Richardson.
Mr. Richardson has agreed to accept the state's offer and plead guilty today.
Very good. Mr. Richardson, if you will raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can place your hand down, sir. Yes, Ms. Falk.
Yes, Your Honor. As for Mr. Richardson, the state's recommendation on that case is going to be on the family violence battery, 12 months or 60 days, credit for time served, 21 days. That is going to be from May 16th of 2025 until today. And I do have an amendment on that. I think the time to serve on that is actually going to be 28 days. Let me just take a moment to check that so we have that right on his form. That is correct. So it would be 60 days, credit for time served, 28 days. Balance probated, FBIP, ADET, 40 hours of community service, no further contact with Trespassing Williams. Count 2 is 12 months concurrent with count 1, and count 3 will merge with count 1. We would at this time like to sound from Ms. Trespassing Williams, and we do ask the defense to stipulate to venue, factual basis, and identification.
Nope, we've moved on. It's not that case anymore.
For the purposes of this plea. That's all for the state.
If Ms. Williams is on the line, wishes to address the court, now is your opportunity.
Sir.
No, doesn't appear that she's with us this morning. Yes, counsel, whenever you're ready. And you're muted there in courtroom too, so.
Mr. Richardson wishes to speak on his own behalf to the court. Sir. Your Honor.
Yes, Mr. Richardson.
There is an issue.
So, Mr. Richardson, let me just say that you have a right to remain silent. Anything you say can be used against you. I'm happy to have you speak with your counsel there regarding that issue to see if you can resolve it. Might be best if you try to do it with him as opposed to speaking with the court this morning.
No, I understand that, Your Honor. It's not that. It's that, I'm gonna be honest with you. I can't lie, that this is not me.
You are not being paid.
This is not me, sir. Can you put, my name is Orion Richardson, sir. Can you pull me up in the system, Judge, Moreau, Your Honor? My name is Orion Richardson. I've been locked up 9 months, sir. And my case is still not indicted. It has exceeded, from my understanding, the statute of limitations, Your Honor. With my case, my name is Orion Richardson, 725.
Okay. So, Mr. Richardson, what I'm gonna do is I'm gonna, it sounds like hold on, listen to me. Sounds like you're talking about another case because, if you're talking an indictment, that's for the DA's office.
Yeah, I'm not indicted. I need
Okay, I understand that, but we don't deal in indictments in this court. So I'm gonna have your counsel there try to clear it up, and I'll put you on another SAP calendar, given that this is not a time.
Answer, sir, please. You every time you open your pie hole, you get it worse trouble. So stay the course.
Mr. Masarkin, and I know
I only played that because you guys were asking for it. This guy should absolutely be speaking up right now. He is not the defendant they're looking for. He's pleading guilty to this. Like, this isn't me. Yeah, no, this isn't me. I can plead guilty for this guy, I guess, but it's not me. Scott, thank you so much for the super sticker. I appreciate it. Very generous of you. Thank you.
Listen to me, sir. Listen, hold on. Listen to me. Listen to me. We're gonna try to clear it up for you. Okay? I have a calendar on Tuesday, so I'm happy to put you on my Tuesday calendar so that we can try to get this cleared up for you. Okay?
So I will do a calendar Tuesday, Your Honor.
Ms. Falk, is there an objection to that?
No. There's not an objection to that, Your Honor. I'm looking at the mugshot for D'Anthony Richardson. This gentleman does not look like him. I did run Orion Richardson.
Yes.
That gentleman looks like the gentleman I'm looking at here on the Zoom. If Your Honor will just indulge and look at the jail screen, it does look like that gentleman. I will say that gentleman does not have family violence battery charges. He does have felony charges for fleeing and eluding, theft by receiving stolen property, reckless driving, willful obstruction, and driving hit and run.
He's probably like, okay, I'll take the other guy's charges instead. Yeah, I want those.
The DA's office, and it shows he's been in jail since November of 2024.
And not indicted. Correct?
That is correct, sir, but that would mean you're not before our court at all on anything. So that's, I guess, Your Honor, I am objecting to bringing him back on Tuesday because it doesn't appear he's actually got any charges with us.
Okay, well, very good. Thank you, Ms. Falk. So, Mr. Richardson, I guess you'll have to clear the other charges up with felony court, but as far as, what are we gonna do with these charges, Ms. Falk, as far as Mr. Richardson is concerned?
I don't think we have the right Mr. Richardson. I think we need to go get the right Mr. Richardson.
Okay.
Based on the jail photo, this is not D'Anthony Richardson.
Okay.
So I have one question for you, disconnect, Ms. Falk and Your Honor. Because there is an issue with what's going on with me, and I don't believe in coincidences or chances. I've been trying to get in contact with somebody. It may have been in the DA's office, but can one of you send an email to my judge or to my lawyer, because it has exceeded past my statute of limitations, and I have a motion that's been in the system since February 10th. It's been pending since February 10th, Your Honor. So I really need some help. And like I said, I believe in God, and something this happened for a reason.
Okay, so I'll have your attorney there follow up and see what we can do for you, sir.
Yeah, a long time.
I understand, sir.
So am I on the calendar? Sir, I'm not on the calendar here today. No, Ms. Falk said Tuesday.
No, you're not.
No, you won't be on my calendar again, sir, given that this is not you.
Okay.
All right, good luck to you, sir. Who do we have next?
Wow, that's what I do. Don't worry.
And Your Honor, if courtroom 2 could actually bring down D'Anthony Richardson, it looks like he is in, well, it looks like he's in Cobb County. So if you could reach out, if there's a way courtroom 2 can reach out to Cobb County and have D'Anthony Richardson brought via Zoom or some other way, that would be helpful.
You hear the request, courtroom 2?
Yes, Judge. Usually they send request the date before, so I can ask to transport, but more than likely it probably won't be today, honestly.
Okay, so if we can't get him today, let's place him on next week's calendar.
Thank you, Your Honor.
All right. That's it. That's all I got. Yeah, that was a fun night. Thank you guys so much for hanging out. I appreciate it. Yeah, I don't really have anything to say. I'm set up to raid Shane. Shane was hanging out with us a little bit ago, so we're gonna raid him. He's doing a impromptu Thursday night stream, so let's go all and say hi to him for a little bit. But yeah, that's all I got. I will see you guys tomorrow. Yeah, I got stop sits tomorrow. Yay! As long as StreamYard lets me actually make some videos. It lets me go live. I just can't record videos. And I kind of need to do that. All right. You guys are awesome. And until next time, bye.